Some cases don't involve bad tenants. This one involves a tenant who did his homework. Patricia followed the process as she understood it. She gave notice, waited the required time, showed up to court with documentation. The judge dismissed the case anyway. Why? Because her tenant had read the Tennessee landlord tenant statute. He found only 2 things Patricia didn't know were there. This is case file 003. I'm Darius Harper, a licensed property manager and the owner of Real Property Management Marble City here in East Tennessee. This is the case that changes how investors in this market think about their lease. Not because the mistake is dramatic, but because it's invisible. Until a judge points to it in a courtroom, what this case is going to reveal the only 3 delivery methods Tennessee courts will accept for a notice to vacate, the clause that could have made this entire situation irrelevant, and how a tenant who knows the law can use your own lease against you. Patricia, 38 years old, a registered nurse here in East Tennessee. She inherited the house from her grandmother 2 years ago. She didn't plan to become an investor, but she was. She couldn't bring it to herself to sell this family home, so she rented it out, self-managed. Patricia was more than prepared. She used a lease template from a reputable real estate website. She ran a background check on her tenant. She collected first and last month's rent, plus a full security deposit. But by any reasonable standard, she was doing the work correctly. Here's what the file revealed when I looked at her lease. It was missing one clause that Tennessee law specifically recognizes, and one that would have allowed Patricia to skip that 14-day notice period entirely and file the detainer warrant the next business day. Her lease didn't have it. The tenant she placed, we'll call him Derek, didn't move in as a scammer. He moved in as a regular tenant, but when things got financially difficult, he just stopped paying his rent. Derek did something most I'm seeing more and more of in Knox County. He opened the tenant statute online and he read it carefully. He found the clause that wasn't in Patricia's lease. Then he waited for her to make the move. He already knew it was coming. Derek moved in. He paid the first 2 months without an issue. Month 3 happens. Rent arrived late with the late fee attached. Patricia texted a reminder and the money came in. She noted it. She just moved on after that. Month 4, nothing happens. Day 6, past the due date. Patricia texted Derek, got no response. Day 10, she tried again. Derek responded that he was dealing with a financial situation and he needed a little more time. Patricia waited 2 more weeks, still nothing happens. Patricia made her decision. She typed out a message to Derek. You have 14 days to pay everything you owe, or I'm going to have to start the eviction process. Please acknowledge this message. The message showed delivered. Then it showed read. Derek did not respond. Patricia screenshotted it. She waited her 14 days. Derek made no payment, sent no communication. She drove to General Sessions Court, paid her filing fee, walked into that hearing with her screenshot, her lease, and her rent ledger in folder. She was organized. She felt prepared. The judge asked her one question. How was the notice delivered? Patricia showed him the screenshot, delivery receipt, read notification timestamp, clear documentation that Derek had received and read the message. The judge dismissed the case because that dismissal is the moment the investigation opens, not closes. The evidence Patricia thought she had wasn't evidence Tennessee courts recognized. And while she's standing in that courtroom trying to understand what just happened, Derek already knows exactly what comes next. When I pulled this case file, the first thing I looked for was the notice. Because in Tennessee, how to deliver a notice to vacate determines whether the clock ever starts running. Tennessee law recognizes exactly 4 valid delivery methods. Personal service. A notice is handed directly to the tenant in person, or certified or first-class mail to the rental property address, or the notice physically posted on the front door of the unit. Also, 66-28-108 Tennessee statute gives you the right to send the eviction notice via email only if the tenant provided their email address in the rental agreement. Those are the only ones. A text message, regardless of delivery confirmation, receipts, or screenshots, does not satisfy the legal requirement. A text doesn't, a voicemail doesn't, a Facebook message doesn't. Patricia's 14-day clock had never legally started, so the judge had no choice but to dismiss that case. But here's where the investigation reveals a second finding, the one that made this case significantly more expensive. While Patricia's processing the dismissal and preparing to serve the notice correctly, Derek was on the phone with the tenants' right organization. They confirmed what he had already knew. The clock had never started, the dismissal was correct, and there was something in Patricia's lease worth noting. No waiver of notice clause. Under Tennessee law, if a lease contains a waiver of notice clause written in 12-point bold font and the 5-day grace period already passed, the landlord can skip the 14-day notice period entirely and file the detainer warrant with the next business day. Patricia's lease didn't have that. Therefore, Derek used every one of those 14 days. He used the dismissal, he used the restart. Every procedural window Tennessee law provided, he walked through because he'd read the statute and Patricia hadn't. By the time Patricia properly served the second notice, waited the full 14 days and refiled, Derek had been living in that property rent-free for an additional 6 weeks. 6 weeks at $1,400 per month, $2,100 in additional lost rent, plus 2 filing fees. Case file 003, final damage was $2,100 in lost rent, 2 additional filing fees, and an eviction that should have been filed weeks early, delayed by 1 wrong delivery message and 1 missing clause. In the lease, Patricia had trusted for 2 years. Here's how this case closes. With the professional property manager process, every notice we serve goes through a legally recognized delivery method. Personal service when possible, certified mail with the tracking as a backup, photographed on the door posting when required, and electronic mail delivery when applicable. Date, time, delivery method, all documented. When we walk into General Sessions Court, the evidence file is complete. Not a screenshot, a legal record. Every lease we use is drafted by a Tennessee licensed attorney and contains a waiver of notice clause in 12-point bold font. Therefore, when a tenant stops paying and the grace period expires, we don't wait 14 days. We file the next business day. For Patricia, the gap between her process and a professional property management process was 6 weeks of rent and 2 filing fees. The tenant knew Tennessee law. The landlord did not. If you're self-managing a rental property in Tennessee right now, pull out your lease and look for a clause in 12-point bold font about a waiver of notice. If there's not there, click the link below. Let's review your current lease and see what's missing before your tenant finds it first. Because in Tennessee, real estate, it isn't what you don't know about the law that doesn't protect you. It protects your tenant.